Good morning. My name is Jeff Stauffer, Community Relations Director with Elville and Associates, and welcome to our webinar today, Estate Planning for the Individual, with our presenter, Elville and Associates Senior Principal and Senior Estate Planning Attorney, Olivia Holcombe-Volke. So briefly, if you haven't joined us before, if so, welcome. We're glad you're here. The way this will work today is you as the attendee are in listen-only mode. However, there is a questions panel on your screen where you can ask questions and interact with me throughout the presentation, and we'll pause to field those questions throughout as well as at the end of the presentation. Also, for certified financial planners, CPAs, and other professionals on today's webinar, you may receive 1.5 continuing education hours for attending. So if I don't have it already, for my records and reporting requirements, please email me your board ID number. And also for CFPs only, I need the last 4 digits of your social security number as soon as possible. And I'll also be sending out CPA CE certificates soon after the webinar. Everyone will also receive a post-webinar feedback email right after the presentation. And we ask that you do please take 2 minutes to fill out this simple survey to offer us your valuable feedback about the presentation. We read every comment and appreciate them very much. You also have an opportunity to request a time for a free consultation with Olivia to discuss your planning needs as well. And we always look forward to being a resource for you, and there's nobody better to guide you through your planning than Olivia. So briefly, I want to give you a little bit of feedback and information about the firm as well as Olivia. We were founded in 2010 in Columbia by managing principal and lead attorney Stephen Elville. We also have a number of different practice areas here at the firm, including estate and special needs planning, elder law and elder care planning, estate and trust administration, business and succession planning, asset protection, guardianship, and a very busy litigation department, as well as tax planning. We have 7 attorneys, 12 staff members in 5 different locations. I'm coming to you from our Columbia Gateway location right now. Our mission, as it always has been and always will be, is to provide practical solutions to our clients' needs through counseling, education, and the use of superior legal technical knowledge. And we do offer a lot of education here at the firm. That's very important to us. And we do that through our planning processes with our clients. We also offer well over 100 educational workshops and webinars in the communities we serve each year. We also offer an accredited client care program, one of only 2 law firms in the state of Maryland that is accredited through the Client Care Academy in Boston. It's a very robust program. A lot of our clients take advantage of. If you're interested in learning more, please email me and I'll get that information out to you. We also work with the ideals of client education, collaboration, and compassion in mind with each client every time. A little bit about Olivia, who is our presenter today, has done many webinars with us as well as in other areas. Olivia's work is centered in estate planning, elder law, estate and trust administration, special needs planning, and asset protection. A very seasoned speaker, presents at many workshops, conferences, and continuing education events each year. She was named to the Maryland Rising Stars list by Maryland Super Lawyers in 2017, named 10 Best for Client Satisfaction in Estate Planning by the American Institute of Legal Counsel in 2018 and 2019. And as I always say, we're very proud of Olivia for all the volunteer work she does in the Central Maryland area. She is a board member for the Women's Law Center of Maryland, a chair for the Judicial Selections Committee through the Women's Law Center of Maryland, also a volunteer attorney for the Maryland Volunteer Lawyers Service. She's a founding member of the MBLS Community Advocacy Network, also named Volunteer of the Month for that organization in May 2019. And she provides trainings to volunteer attorneys on advanced directives, financial powers of attorney, and wills and deeds. So that's a little bit about our firm and Olivia. So we're going to go ahead and get started now. We're going to do a brief poll just to see what the state of your estate planning is. So I'm going to launch this poll and appreciate it if you take part in it. It'll just take about 60 seconds. So the question is, what is the state of your estate planning? And the options are, let's see here, I don't know where to begin. Help me. I established a plan a while ago, but it needs to be revisited. My plan is signed, sealed, and delivered. I'm in good shape. Or I'm an advisor here to learn how to educate my clients. So if you can, choose the selection that best describes you so we get an idea of who's here with us today. We'll give it about another 10 seconds or so. All right, so we've got about just under 90% having put their responses in. 16% saying, I don't know where to begin, help me. And that's not abnormal with this presentation. A lot of individuals, as Olivia will say, don't think they need an estate plan, and that's not true. Everyone needs an estate plan. 50% say, I established a plan a while ago, but it needs to be updated. 13% say, my plan is signed, sealed, and delivered. I'm in good shape. That's great to hear. And 22% say, I'm here to learn how to educate my clients about planning. So we have some financial advisors here, and welcome, we're glad you're here. Thank you very much. So with all that being said, I'm going to turn it over to the person that you actually want to hear talk, Olivia. So Olivia, I'm going to click the button, and that's going to give the controls over to you.
Excellent, thank you, Jeff. And let's see here, are you able to actually see my screen at this point? It looks like you have to close the poll to enable.
Yeah, let me go ahead and try to do all that. 1 second here. I apologize for that. I've never done that before. All right, let's try that again. So you should have the controls of the presentation at this point. Can you pull up your screen? There we go.
Okay. Let's see if we can get the slideshow working. Well, good morning, everyone. Thank you very much for that introduction, Jeff. So I am Olivia Holcombe-Volke. I am a senior principal at Elville and Associates. And as Jeff said, my primary focus is estate planning, but I also do a lot of work in special needs planning and asset protection planning and tax planning that kind of goes along with all of that. And the focus for today's conversation is estate planning for the individual. The reality is that estate planning as a broad topic is something that's relevant to every adult. And I'm going to explain what I mean by that. And I'll spend the first half of the presentation really doing a general overview of estate planning, the fundamental pieces of it. And then in the latter part, I'll talk about some more specific considerations that may be more relevant to individuals, although are certainly also relevant to anyone and everyone who needs to do estate planning. My starting point with estate planning, because I often find that when I meet with people, their conception of estate planning is that it deals with what happens when they pass away. So most people are familiar with a last will and testament, and most people are familiar with the idea that that deals with what happens with your stuff when you pass away. But estate planning is actually a much bigger topic than that, and it covers more than that, and there's actually as much that's vital with regard to while you're still living but perhaps incapacitated as there is to what happens after death. So my starting point when talking about estate planning is to help frame the conversation in terms of what we are going to be talking about is not simply what happens to your stuff when you die, but also what if you're still alive but you lose your ability to manage things for yourself, whether it's your own health and medical decisions, or your finances and property and the decisions and actions that need to be taken there. So estate planning incorporates both what happens after death, but also what happens in the event I'm still living, but I lose my ability to manage things for myself. Frequently, people do think that estate planning is something that is only relevant if you're elderly, or if you're wealthy, or if you have a complicated situation. So unfortunately, many people do perceive that they, in fact, do not need to do an estate plan because they don't fall into any of these three categories. And what I will talk about and what I will say repeatedly is that the reality is estate planning is important for every adult, regardless of age, regardless of wealth, and regardless of simplicity or complication. And the starting point for that is talking about incapacity planning. And here, what we're really talking about is avoiding guardianship. So what does that mean? Often people are familiar with the term guardianship in terms of minor children. So they associate guardian with this is the person that's responsible for a minor child in the event the parents pass away. But there are adult guardians as well. And that is something that is relevant when an adult, which means someone over the age of 18, loses their mental ability. And if they have never signed legal documents giving another person permission to act on their behalf, what ends up being necessary is that the court actually has to get involved. And the court will appoint a court-appointed guardian to be responsible for that incapacitated adult's healthcare and medical decisions and financial and property management. So guardianship, when we're talking about an incapacitated adult, is a court proceeding. So most people, in fact, all, would agree that they never want to be subject to a court-ordered guardianship. It's an embarrassing thing to go through. It's an expensive thing to go through. And it really and truly takes away your autonomy to have made the decision yourself about who it is that will be in charge of your healthcare and your money, if not you. So how do we avoid the risk of that? And that's what incapacity planning is all about. The documents that accomplish that are called the Advance Medical Directive, which is the healthcare power of attorney, and then the financial powers of attorney, which are broken into two different documents, which I'll talk more about. The Maryland statutory form, and then a secondary supplemental form with the title Durable General Power of Attorney. So healthcare decision-making. In Maryland, the document that deals with that is called the Advance Medical Directive. In some states and some jurisdictions, this is known as a healthcare power of attorney. And there's also a term that people have frequently heard, which is called the living will. And in Maryland, there is one document that incorporates both the healthcare power of attorney, which is where you are actually designating another person as having your permission in certain circumstances, such as when you are not able to make your own healthcare decisions. You have designated this person, called your agent, to be able to make healthcare decisions on your behalf. And the living will is the section of the Advance Medical Directive where you are actually giving instructions regarding what end-of-life treatment or medical treatment you want to receive or not receive in certain medical situations. In Maryland, those are broken into 3 categories. One is called terminal condition, one is called persistent vegetative state, and one is called end stage condition. So taking a step back, the idea with the Advanced Medical Directive is that it's the document that allows you to name your agent, which is the person that you want to make decisions about your health care if you need them to. And here I always recommend that you name at least 1 primary and 1 backup. But people ask me all the time, can I name 3 or 4? You can name 10. It doesn't matter how many you name. And in fact, the more, the better, because that way you're avoiding the risk that if someone you've named is also incapacitated or also happens to be deceased in that time, that you've got someone who can step into their shoes to make sure that you're still protected and you've still got someone who can take action on your behalf. So the Advanced Medical Directive allows you to name those agents, and then it allows you to go into detail about what is the point in time when they will be able to act on your behalf. What are your instructions if you're in a persistent vegetative state or end stage condition or terminal condition? It also gives you the ability to talk about things that are more personal to you. Do you have preferences with regard to if you're in an end-of-life situation and you cannot communicate? Do you want to make sure certain things are known? Like, I want to be able to listen to mystery books on tape or classical music, or be near a window and taken outside regularly, or have my dog visit if possible. These are all personal preferences that are frequently overlooked within the legal documents. Something that I always mention to clients is the idea that while you can put that sort of personal detail into the Advanced Medical Directive directly, it does not hurt to actually think of writing a separate letter of wishes or letter of instruction, where what you are doing is going into more personal detail about all of those sorts of things that are personal to your comfort or your preferences or your peace, going into more detail about all of that for the sake of a person who may one day be handling things on your behalf. It's giving them additional insight and guidance on your personal preferences. And that letter is something that you simply keep with your legal documents, provide to the person that you've named as agent, and you can keep it updated as your preferences change. But the Advanced Medical Directive does allow you on a few lines if you want to actually include such preferences in the document itself. One interesting thing about Maryland's Advanced Medical Directive is that it actually gives you the ability to designate whether or not your agent has to follow your instructions literally, or whether they have any discretion. So these are called flexibility provisions. And the idea with this is that none of us have the ability to see into the future. And so at the point in time when a healthcare agent may be making decisions about your healthcare, the things that you were thinking about and the medical realities that you were aware of when you actually created the document may be different at the point in time when it's being implemented. And so there's some appeal for some people with the idea of giving the healthcare agent some discretion. Their guidance is that they are to follow your instructions unless something different, unless a deviation is actually in your best interest. And that's just a choice that you have. That's part of the Advanced Medical Directive, that you can say whether or not your healthcare agent has that flexibility. Finally, the document covers whether or not you wish to be an organ donor and what your final arrangements should be if you have certain preferences with regard to funeral and burial or cremation and memorial service. And then it allows you to go into a little bit more detail if you wish. Now, one thing that people frequently ask me is, does this include the DNR? That's do not resuscitate. The answer is no. So Dnr preferences are actually covered in a document that's called the MOLST. That stands for Medical Order for Life-Sustaining Treatment. It is a document that is actually signed by a physician. It is a medical order, and it dictates whether or not you wish to be resuscitated. So that is something that I mention to clients and that I ask them to talk with their physician about, because their physician will really be the more appropriate person to guide them through that document and help them be able to sign it or get it in place if they so desire. Although we do have literature on the MOLST that we're happy to share with clients if they so desire. So that was the medical and healthcare decision-making pertinent to while you're alive in the event you are unable to make those decisions for yourself. Now we'll shift gears to the financial aspect. So if you are alive, but for any reason need help with regard to your finances, assets, property, this is covered under the financial power of attorney. We utilize two documents to accomplish this important planning tool. The first document is called the Maryland Statutory Form, Personal Financial Power of Attorney. This has a lot in the title. It comes directly out of Maryland statutes, out of the law of Maryland. So approximately 10 years ago, the Maryland legislature recognized that there was no standardized form, financial power of attorney. And as the result of that, people were frequently creating their own. They were simply writing their own power of attorney and then thinking that they had what they needed in the event it was ever necessary. And then frequently what was happening was that banks and other financial institutions were rejecting these homemade or personally made documents and saying, we don't believe this is valid, so we're not going to recognize it, which then left people unprotected who thought that they had done the documentation they needed to. So the legislature stepped in and said, enough. They have created a standardized form, power of attorney. And in Maryland law, it says if you use this form exactly as it's written in the law, and the only changes that you make are to the names of the people, and you have a little bit of special instructions that you can give, but otherwise, if you use it the way that the legislature wrote it, it is mandatory that financial institutions accept it. So it's an extremely powerful tool. And it's the one that we use as the starting point because we know that it has the mandatory acceptance. However, it's limited in what we can customize because, as I said, it's basically a take it or leave it document. If you use it, it's mandatory that it be accepted. But if you change it at all, you are risking that that ruins the mandatory acceptance. So you have limited ability to customize it. And that's the reason that we use a secondary document to supplement the Maryland statutory form. That's called the General Durable Financial Power of Attorney. And in that document, we cover additional powers that are not covered in the Maryland statutory form. And I'll talk a little bit more about what I mean, but that's the reason for the two documents. They work together. They don't revoke each other. They don't replace each other. They supplement each other. With the Maryland statutory form, you know your power of attorney will get their foot in the door. And then if they need to actually take action that's not covered under the Maryland statutory form, they present the supplemental general durable form where those extra powers are covered. So what is it that a financial power of attorney does? Well, just as the Advanced Medical Directive does for your healthcare decision-making, the financial power of attorney does the same thing for your financial decision-making. It allows you to actually designate an agent, which is the person that you are giving permission to step into your shoes and take whatever action needs to be taken on your behalf, not for their own benefit, not for their friends or family's benefit, for your benefit. They are stepping into your shoes and acting on your behalf for your benefit with regard to your finances and assets and property. So the reality is that people assume that this is only relevant when they are incapacitated. And of course, that's the primary purpose. The primary purpose is, again, to protect you against the risk of guardianship in the event you ever lost your mental capacity. So it is true that a financial power of attorney is mostly necessary if you lose your mental capacity. But under the law, the default is that it is in fact effective the moment that you sign it. That strikes fear in the heart of many people, and so I always take time to explain that does not mean that you have given up power over your property and your assets, and that now your power of attorney has all the power and you don't. That is not what it means. It means simply that they are able to step into your shoes and take whatever action needs to be taken without needing to actually have certification from doctors that you are incapacitated. There are circumstances where it actually can be useful to have it be immediately effective. Maybe you're traveling out of the country and something local needs to be signed. Or maybe because of a pandemic, you are not safe to leave the house and you need someone to go to the bank for you. So there are circumstances where it can be useful that it's immediately effective. And what I always kind of get down to the bottom with people is, why do you feel more comfortable having someone be in charge of your money when you're incapacitated than you do having them be able to do what they need to do for you with your money while you have the capacity to see what's going on and to observe if things are happening with your accounts that shouldn't be? So that conversation usually helps me get to the bottom of what might be going on, because if that is concern that the people you're giving this power to may abuse it, that's something we really need to talk about, because it is very big power to give someone the ability to touch all of your money. So it is something where we really do need to think through and discuss who you're giving this power to and whether or not they are the appropriate person. Ultimately, we certainly can write the document to say this is only effective upon my incapacity. So you do have that ability. It's just something that I always think is a worthwhile discussion to have. So the Maryland statutory form, mandatory acceptance, it covers most bases. It basically, in a boilerplate, broad brushstroke way, says, I'm giving this person, and again, name backups, I'm giving this person general ability to step into my shoes and take action with regard to my assets. The things that are not covered in the Maryland statutory form, and the primary reason that we use the supplemental general durable form, is there are several powers that are not covered in the Maryland form, and those are the power to make gifts, the ability to actually do gifting with your assets, the power to do trust planning, to create revocable or irrevocable trusts on your behalf with your assets, the power to keep your beneficiary designations on your retirement assets and your life insurance updated and current with whatever your estate plan which is of course your will or your revocable trust, to keep those current with your plan. All of these extra powers are really mostly motivated by tax avoidance planning or tax minimization planning that may need to be done at some point. And if you're not able to do it for yourself, this is making sure that your power of attorney would be able to do it for you. And also asset protection planning. These are key powers that if you are not able to use for your own assets, it's important that you've made sure someone else can do on your behalf, because certain asset protection strategies may be necessary. And if you're not able to do so, this is making sure your power of attorney can do so. Again, all motivated by acting on your behalf in your interest for your benefit. And a lot of that is also Medicaid planning. Those tools and those powers are frequently necessary when we're doing Medicaid asset protection planning, when someone is in need of skilled nursing and we want to get them eligible for Medicaid to pay for it. So financial powers of attorney protects you against the risk of guardianship if you lose your mental capacity, and make sure that you've provided for the ability of a trusted person of your choosing to step into your shoes and take action with your money for your benefit in whatever way that may be necessary. Jeff, do we have any questions so far?
Not at this time, Olivia. Everyone's
Okay.
listening intently. Please do ask questions, everybody, if you have them. I'm sure there are some out there. So be sure to take this opportunity. You've got Olivia right here, ready to answer them. Thanks.
Thank you. So having talked about these documents that deal with your healthcare decision-making or your financial decision-making, who is the appropriate person to give that responsibility to and to give that power to? And that's an important thing to be aware of. It's not only you deciding who you would be comfortable having this power and having this ability to act on your behalf, but another part of it that's really important is thinking about who would be the most appropriate person to have this responsibility, because it can be a job. So whenever I'm talking with clients about the appropriate people to name in these positions, it's not only vital that it's someone that you trust implicitly to act in your best interest, but it's also really important to think, would this person be able to do this? Not only from a savvy standpoint, but also, is their life totally overloaded? Do they have already so many different obligations and responsibilities pulling at them? Will this really be something that they will be able to do on my behalf? Because of course, when you are creating these documents, you are creating them with the intention that they will succeed if they are ever needed. So you want to be certain that the people that you name in these roles are likely to be able to actually carry out these functions on your behalf if it ever became necessary. And this is a good reason and a good opportunity for me to mention estate planning documents are not meant to last forever. It is vital that you revisit and update them. I tell people every 3 to 5 to 7 years is a good rule of thumb. The older that you get, or if you have an illness or other kind of disability, it may be important to revisit and update them more frequently. But even if you are young and healthy, these are not documents that are meant to survive for decades. It is vital that you revisit them on a regular basis. And the reason is not only to make sure that the people that you've named in the documents are still the appropriate people, but also to allow you to revisit the thoughts and decisions that you made when you created the documents. Those are going to change over time. Your preferences, your concerns, your goals, that's going to change over time. So you have to revisit those thoughts and the documents. But most importantly, the law changes. So the law of 30 years ago is not the law of today. And in order for your legal documents to actually be current with the law, with your preferences and goals and concerns, and with the reality of the people that you're giving these responsibilities to, you do have to regularly revisit and update them. So figuring out the appropriate person or people to name in certain roles is a conversation that I have with clients. Options are always relatives, friends, or sometimes the best option is to actually name a professional. So shifting gear now to after death planning. So after death planning, first of all, the thing that I always tell people is there are many, many options. There is a spectrum of options that everyone has for what documents and what structures they want to use for their after death planning. And the appropriate tool or legal structure is different for different people depending on the circumstances. So there is no one standard estate plan for everyone. But the most fundamental and the most commonly appropriate documents are a last will and testament, which most people have heard of, or something called revocable living trust, which most people either have heard of, but they don't know exactly what it means, or they've never heard of it. It's something that I always cover because it is a good alternative option to a last will and testament for many people who don't realize it. So when I cover the after death planning options, depending on the circumstances, almost always the best choice for people is one of these two planning tools. So what are the differences between them? So we'll start with the last will and testament. And the piece of this that I find most often comes as a surprise to people. A last will and testament is subject to probate. So let's pause for a moment and talk about what that means. First of all, what is probate? Probate is a court process, the probate court. When does probate have to happen? It has to happen when there's an asset with no living owner and no designated beneficiary. When there's an asset and the last living human owner has died, and it does not have a designated beneficiary, in order for that asset to go from that deceased owner to whomever is going to inherit it, it has to go through probate. So that's the trigger for probate. And probate is a court process where the paperwork is filed with the probate court to say there are these assets, the last living owner has died, these need to go through probate in order to go to the people who are going to inherit them. The probate court then asks, is there a will? So if someone died without a will and now their assets are going through probate, the court relies on what the law of Maryland says in terms of where the assets go when there's a probate estate that's called intestate, which means that there is no will. So in that circumstance, the court relies upon Maryland's intestacy laws. If there is a will, then the probate court relies on what the will says. Now, of course, the will has some risk of being challenged, and there's no guarantee that the will be respected as valid. That's part of the probate process, is making the determination that it is valid. But if it is, then that is the document that guides the probate court on where the probate assets are supposed to go, who is supposed to inherit them according to the will, and who is supposed to be the executor to manage that process under the probate court's supervision. In Maryland, an executor is actually called a personal representative. So I say this to say that I find frequently people think, I have a will that avoids probate. When I die, my will just dictates what I want to happen, and it will happen. That is not true. A will is only relevant in probate. So the probate process involves first opening the probate estate with the Register of Wills office, and it has requirements for paperwork that has to be filed and information that has to be shared with the court. The court needs to know, what are the assets that are part of this probate estate? It has to be that the creditors of the deceased person are given an opportunity to say, this person owed me money, I get paid from the estate. So there's the creditor claim period. And the court requires regular accountings in order to keep tabs on how are the assets in this probate estate being collected, used, dispersed. They have to be provided with an accounting regularly in order to make sure that everything's being handled appropriately. And guess what? That comes with cost. The court doesn't work for free. And the people who are handling the probate process, the personal representative, the attorneys who are assisting, none of that comes for free. On average, we find that the cost of probate usually runs about 4% of the size of the estate. And another important piece of this is that it's entirely public. So probate is public. The documents that are involved in probate can be seen by any member of the public. It is a public proceeding that anyone has access to. And that matters, especially when I'm working with people who perhaps want to disinherit someone. It's really important that we talk about, is it a good idea to try to avoid probate in order to minimize the opportunity that this disinherited person might have to challenge things? So that's always a piece of the conversation that's important to have. But other people are just motivated to avoid probate because they want to avoid the need for the court to be involved, and they want to avoid those costs. So we'll talk about how to do that soon. But
Olivia?
Oh, yes, Jeff, please.
Can I pause you for just a moment to ask a couple of questions?
Absolutely.
Okay. So one question is, when do you discuss most with a doctor? My understanding is it is so serious, usually presented when someone becomes ill.
So my answer to that question is that the most is implicated and relevant only in certain situations, but the opportunity and timing to have the conversation with your doctor is personal to you insofar as your feeling about wanting to make sure that your wishes, if you have any, I mean, if you have an opinion or a feeling about whether or not you would want to be resuscitated, then having that conversation with your doctor, I would say it's relevant the next opportunity that you have, or even just to know a little bit more about it so that you know when it's the appropriate time for you to really start doing that planning. So as I say, we have some very helpful literature that we can share with anyone who would like it. In fact, it's available online but we can share the literature to just help educate you a little bit more about when the most is relevant, what it really covers, and that can help guide you on when you might want to have the conversation with your doctor.
Yeah, and I think that's a great idea, Olivia. And as I think we did the last time we had this presentation several months ago, I'll go ahead and send out that most packet that we have here at the firm to everybody as a PDF so they can look over it if they choose.
That's great. Thanks,
The
Jeff.
last question, oh, my pleasure. The last question we have for now, it's a two-parter related to insurance and your thoughts around it. Do you suggest to clients that they plan for long-term care and seek coverage for the cost of care as part of retirement or incapacity planning? And then that kind of second piece to it along those same lines, suggesting to younger clients they consider disability income insurance to protect their income.
So the answer to the long-term care insurance question is that long-term care insurance is an investment. And so the appropriate professionals, in my opinion, to provide guidance on whether or not long-term care insurance is an appropriate investment for you to make, the appropriate professional will be your financial advisor. And allow me to say, if you do not work with a financial advisor, I highly recommend that you start. And that is a question that would really be appropriate for that professional because it is an investment. And so my answer to that when clients ask is it's not something that's the right idea for everyone. And the appropriate professional to guide on whether it's appropriate for you in terms of your assets and the best use of them in terms of an investment, that person will be a financial advisor. And as to the second question, I'm not an insurance person, meaning I'm not an insurance agent and I'm not an expert in any of that. But what I would say is I've always been taught, and I very much believe that it is quite important to make sure that you have some sort of coverage for your income in the event you lose it because of a disability that takes you away from the ability to work. So I do think that it's a wise idea to make sure that you have appropriate disability income insurance. And then again, I would refer people to the appropriate professional to actually talk about what that looks like, what amount that might be, and so on and so forth. But my inclination on that one is to say yes.
Okay, thanks, Olivia, for now.
All right. So wrapping up the will conversation, this is just a visual diagram of if someone utilizes a last will and testament as their death document, for lack of a better way of saying it, their estate plan will look like this. They will have the lifetime incapacity protection planning documents that we talked about, the advanced medical directive and the financial powers of attorney. And then they will have the last will and testament, which will kick in at death and of course will cover the probate assets. So then we turn to the alternative fundamental document. So again, there are many options and many tools, and different ones are appropriate for different people. But for the majority of people, the right options are either the last will and testament or the revocable living trust. And here, the very first thing, what is a revocable living trust? It's a way to avoid probate. That's what it accomplishes. That is what it accomplishes. It does not provide you with asset protection. When you create a revocable living trust and put your assets into it, those assets are still yours as long as you are alive. So if you get sued, there is no additional barrier because you put them into a revocable living trust. So often people think a trust means asset protection. There are trusts that mean asset protection, but a revocable living trust is not one of them, nor does it provide tax savings. The revocable living trust is to avoid probate. So what is a revocable trust? Just like a will, it's a piece of paper. It says what you want to happen with your assets when you die. But it is actually a contract that comes into existence when you sign it. And after you sign it, the next and most important part is that you fund it. And funding means making sure that your assets are coordinated or aligned with the trust to actually be controlled by what the trust says. So to break it down a little bit more, because it is this very vague, very difficult concept, it's a piece of paper that is a contract. The terms of the contract set forth how the assets that are under the control of the contract are to be used, invested, managed, and ultimately distributed. In the beginning, the contract is entered into between you creating it. You're called the grantor or the settlor. You write the terms of the contract because you're putting the contract in control of your assets. On the other side of the contract is the trustee. That person is simply following the terms of the contract with regard to the assets under its control. In the beginning, you are on both sides of the contract. You are the grantor writing it, and you're signing it with yourself as the trustee. And then you're actually changing ownership on your assets. For example, your house. It's no longer owned by you as an individual human. Now it's owned by your revocable trust. People get scared at the thought of that. Wait a minute, I don't want to give up control of my house. Well, of course you don't. Absolutely, completely. That makes perfect sense. The revocable trust, it's revocable. You can revoke it at any time. You can amend it and change the terms at any time. And you can take the house back out or sell the house or do anything that you want with the assets as long as you're alive and have mental capacity. None of it takes power away from you. And as long as you're living, it's associated with your social security number. So there's no change to taxes, no impact on taxes. It really is just kind of this alter ego. But then when you become incapacitated, you've named in the document the person who steps into position as your backup trustee. And they step into position and all they're doing is following the terms of the contract, which says, as long as I'm still alive, the money in here and the assets in here are still to be used for my benefit. And then you die. And the trust says, here's the person who acts as the trustee after my death. And here's what they do with the assets. They distribute them to my children, for example. This is how it avoids probate. Because remember I said probate happens when there's an asset with no living owner. When a revocable trust owns your assets, it's not a human. So when you die, the trust doesn't die. It's an entity. All that happens is that we turn to the next page where it says, after my death, the assets that are under the control of this trust go to my children. And the trustee carries that out. So it's a difficult thing to explain how a trust works and what it is, but I hope that that helps make it a little bit more understandable. And that is how it accomplishes avoiding probate. And by avoiding probate, we do find that typically the cost of a revocable trust, the administration of it, tends to run more around 2% of the size of the estate. Let's see, there was one other thing I was going to say about the revocable living trust. I can't remember. So that's the revocable living trust. It is utilized to avoid probate. So when someone has a revocable trust-based estate plan, they again have the lifetime incapacity planning documents, the advanced medical directive, and the financial powers of attorney. There are some ancillary documents that go along with the revocable trust called assignments, which are just simple documents saying, I'm assigning ownership of my jewelry and my furniture and my artwork. This is now owned by my trust. And you will still have a last will and testament, which causes a lot of confusion. The last will and testament, which goes along with a revocable trust, is not meant to be used. It is not meant to be relied upon. Its purpose is one thing: just in case an asset didn't get properly aligned with the trust, and at your death, the result is you do in fact have a probate estate. This is where your last will and testament wakes up. And what happens is the will directs your probate estate to pour over into your revocable trust. And it's called a pour over will for that reason. So our goal is to make sure that every asset that you have is properly aligned with your trust so that there is no probate. But just in case, we have you sign a pour over will as a safety net to catch anything that might go through probate. So that concludes the fundamental pieces of most estate planning structures. Special considerations that are just always part of the conversation that we need to have are with regard to who is it that you intend to benefit with your assets after death? Who are the beneficiaries that you want to benefit after your death? And do you have any dependents while you're alive that you need to make sure are properly taken care of and provided for after your death? So some topics that are part of this discussion are inheritance tax. Maryland is one of the few states that has this particular type of tax. It's a tax that is assessed against certain people inheriting from the deceased person. So what I mean by that is spouses and children and grandchildren and parents and siblings, there is no inheritance tax. But friends or cousins or nieces and nephews, inheritance tax applies to them inheriting from your estate. And that's just something we need to talk about if those are people that you want to leave money to. Income tax is also a relevant conversation. This is mostly relevant in terms of if you have IRAs or 401ks or 403bs or TSP, any of that type of asset, income tax is a relevant piece of that type of an asset, even after your death. And so the amount of income tax and the timing of when it's due is dependent upon the beneficiary that you are leaving that account to and the way in which you are leaving it to them. So that's an important part of the conversation that we need to have. Income tax can also be a relevant piece in terms of capital gains and talking about how is capital gains relevant in terms of assets that are inherited. Of course, if minor children are part of your world, we need to talk about planning for them. What if they are still minors when you pass away? Not only do we need to make sure you've named who you wish to be their guardian or guardians, which is the person who's responsible for their physical well-being and education and all of that, but also we need to talk about the structure of the money that you will be leaving for them. How do you want that to be handled and by whom? So that's an important part of the conversation. If there are incapacitated or individuals with special needs who are part of your world, whether dependent upon you now or that you're intending to leave money or property to at your death, this is relevant because we're talking about someone who perhaps can't manage money on their own or can't manage their care on their own. Or we're talking about someone who is eligible or may be eligible for government assistance. And we want to make sure that we don't ruin their eligibility for that government assistance by leaving them money outright. So these are things that we have to talk about and build specific planning structures for. There are other non-probate devices, and I always think this is important to mention just because I do find that frequently people say, well, I know how to avoid probate. I'll just add my child's name to my deed, or I'll just go ahead and give things to my child now. Non-probate devices other than trust planning, it is important that we do so very carefully because there are a lot of risks that people are not aware of. And it doesn't mean you shouldn't do it this way. It just means I want to make sure that you're doing it knowingly. Because some of the risks, there are many, and part of my counseling is talking through all of those, but a few of the big ones. If you add someone else's name to an asset, you are also adding their creditors. So it is not a good idea for you to add someone else's possible creditors to your asset. There are better ways to avoid probate where we also avoid the risk of adding and exposing your assets to someone else's creditors. Another piece of it is gift tax and capital gains tax are things we need to talk about when we're talking about adding someone's name to an asset. Other strategies like making things payable on death or transferable on death, beneficiary designations, life estate deeds. These are all tools that we sometimes utilize and sometimes that we need to utilize as part of the planning. But I never recommend relying on these tools alone without the guidance of an attorney and without the guidance of a financial advisor to make sure that you're aware with regard to your particular assets, your particular intentions, and any of the risks that may be part of it, that you accomplish the best plan for you. And frequently that ends up being a plan that involves both a last will and testament and some of these other devices, or a revocable trust and some of these other devices. But I caution people against thinking these other non-probate devices are a sufficient way to plan for your estate on their own. They are not. Ultimately, my point is to put it in writing. You know what your intentions are. You know what your goals, what your concerns, what your assets, you know all of that. The best way that you can make sure that things will go according to your plan, whether you're still alive but simply need help or are incapacitated, or after death, the best way that you can make sure your intentions are accomplished is to put it in writing with the appropriate estate planning devices. And that's the end of the presentation for today. So Jeff, I don't know if there are any other questions.
Well, thanks, Olivia. And we do have some additional questions. Thank you so much for being so thorough as always. Great detailed explanations that are clear in language that people can understand, which is a lot of the feedback that we get from your presentations, which I know people appreciate. So thank you as always. And so I think we have a few questions and comments. The first one here is from Roseanne. So you know Roseanne.
Hi, Roseanne.
Hi there, Roseanne. She has to say that that was the best explanation of a will versus a trust that she has ever heard. So
thank you.
Nice job. So that's coming from Roseanne. So I know we all appreciate Roseanne here and miss her. And she's doing well. So next question, can you give examples of administrative costs of a revocable trust?
Certainly. So what one of the things that I always explain is that when we do a trust plan, what we are doing is removing the element of probate. So what we are doing is removing the element of the probate court's oversight and involvement and the public ability to see and oversee the process. We are removing the estate from that. But what we aren't doing is removing the need to actually go through an administrative period after the creator of the trust dies. So the way that I explain it is, when someone dies, their financial existence is not immediately over. There are administrative steps that have to be taken. Final tax returns have to be filed. Final expenses and debts have to be paid. Money that's owed to the deceased person has to be collected. Property may need to be liquidated. So a house may need to be fixed up and sold, or tangible personal property, a piano may need to be housed in storage before it can be transported to the person receiving it. So these are the administrative steps that still have to be taken even when we have a revocable trust. It's just that they won't need to be taken under the supervision of the probate court. So the administrative expenses are all of the expenses that go along with that administration, including CPAs or other tax advisors or tax preparers who may be assisting with the final tax returns, attorneys who are helping with, these are the steps that need to be taken. You know, a trust after death is administered privately, which means it's not subject to public oversight and it's not in the court system. But there are still laws that dictate certain actions that have to be taken with a trust after the creator, the grantor, dies. So there are requirements that the beneficiaries have to be given notice of the existence of this trust that they are going to benefit from. So all of that is stuff that the trustee may not know. These are steps that need to be taken. These are actions that need to be taken. And that's where I really do encourage that people do hire an attorney to help with that process. The trustee will be the one doing it, but they certainly benefit, and in fact, I think need the assistance of an attorney. And that's a big part of what we do at the firm, is assist with trust administration after someone dies. So the administrative expenses are paying for the assistance of professionals, paying for the costs of filing final taxes and paying the final taxes, and perhaps paying a realtor to sell the house. And so those are the sorts of administrative expenses that can come up, just depending on what the assets are.
Great, thank you. And to piggyback on that question, the 2% that you mentioned for trust administration, is that a per year item or per what exactly?
Sure, that is a general average. That is a number that is arrived at based upon the cost on average of the total expenses that come out of someone's assets from the point of creating the revocable trust to begin with, and the fees that are paid to do that and to do that plan and the steps that need to be taken to put that plan into place. From that inception and the fees there, all the way through to when the trust is fully liquidated and terminated and over. On average, the total fees and expenses and costs tend to run around 2% of the size of the estate. So that's what that number means. And again, it's an average, so it's not every trust is 2% every year. That's not what that means. It just means on average, we find that people who implement revocable trust planning, the total amount that comes out of their assets overall on average ends up being about 2%.
Okay, thank you. Next question, is the special needs trust fund established when you create an estate plan, or is it created separately? Also, is there a monthly fee maintaining the trust fund?
So a special needs trust is a type of trust to hold money for the benefit of a special needs beneficiary. And the purpose of it is to provide not only a structured way, a controlled way for that money to be used for that special needs beneficiary. It also protects the special needs beneficiary's eligibility for government assistance, because the money in the special needs trust is not considered the special needs beneficiary's own money or own asset. So that's a general statement on what a special needs trust is. It can be created either internally to someone's will or someone's revocable trust, or it can be its own standalone document, its own standalone trust that exists independent of the will or the revocable trust. And there are different reasons that people choose one or the other. One of the easiest ways to think about it is if you do a separate standalone special needs trust, it will exist as of the point in time that you sign it. So if someone other than you dies and wants to leave money for the benefit of that special needs beneficiary, now they have a vehicle that they can direct that money to go into when they die. That vehicle will already exist and be available to receive money whenever someone dies, which of course we cannot predict when that will happen. So that's often a reason for doing a standalone special needs trust, is if someone other than you plans to leave money to it at their death. Another reason is it, by being its own standalone separate document, it allows us to go into much greater detail and customization, which is appealing for many people. Once a special needs trust has money in it, what was the other part of the question, Jeff? I apologize. Is there a yearly fee?
Yes, is there a yearly fee associated with something like this?
So in terms of yearly costs, first of all, a trustee is entitled to compensation. So a trustee is entitled to compensation. So if a trust is active, that means that there is a trustee actively working, and the trustee is entitled to compensation. It doesn't mean they have to take it, but they are entitled to it. So that's one element of a yearly cost. Another element is that a trust, a special needs trust, when it's an irrevocable trust, which there are times where we do one versus the other. Sometimes it's revocable, sometimes it's irrevocable, and this is all just part of the conversation that I have with clients. There are different reasons for choosing different approaches. But if it's irrevocable and it has its own tax identification number, not a social security number, but its own EIN, every year a tax return has to be prepared and filed. So that's an annual fee for paying a CPA or tax preparer to prepare that annual tax return. But otherwise, there aren't, I mean, again, administrative expenses, if an attorney is being paid to help provide guidance, or if a financial advisor is being paid to help know how best to invest the assets in the trust, those fees, those professional fees may be part of it. But in and of itself, there isn't a fee that goes along annually with a special needs trust. It's just the costs of administering a trust. So I hope that's helpful.
It is, thank you. Next question, can you speak a little bit about having professionals being your financial power of attorney?
Yes, so what I always mention with professional options in these roles is, first and foremost, it does require making sure that the particular professional that you may wish to name is actually able to do so. There are some conflict of interest concerns that we have to make sure. For example, if you want to name your financial advisor as your financial power of attorney, frequently that's not something they are allowed to do. So it's just necessary to have a conversation to make sure, if you're going to name a professional, that they actually are able to do so. But beyond that, what I explain in my view is that naming a professional comes with the benefits of, not only will they presumably know what they're doing, and so you don't have to worry about that, but also they will be maybe more of a secure option because they will be acting as a professional. So they will have that higher level of professional responsibility and professional standard that they have to meet. So you may be more confident that they won't misbehave or mismanage or make mistakes. So that's a benefit. And another benefit is they'll be doing it as a job. So it won't be a burden to them in their spare time. It will be part of their professional work. The downside, although maybe that's not the right way to say it, but typically that does come with more cost. So usually naming a professional to serve in a particular role, they will be paid at their professional fee level. And that typically is more than a friend or a family member may get paid in compensation. So it's a trade-off. I do think it's a very good option for many people, but that's just part of thinking through, for you in particular and the situation in particular, are all of those circumstances best for you?
Okay. Next question. It appears that the cost of the revocable trust is less than the cost of probate. Would you say that is true?
That is true. And so let me fill in the gap as to why in the world would anyone go with a will? And that's a common question. When I go over things this way, people say, well, it seems obvious that everyone should do the revocable living trust. The reason that sometimes people choose not to do that is because the revocable living trust is a more costly endeavor up front. So when you do a will, it's less expensive for you up front because there is more of the expense that comes out after your death in the probate process. And when you do a will, it's less work for you up front. It's just a document. You don't have to retitle assets. You don't have to go through all of the funding and asset alignment. You just have a will. That's a written document, and that's the end of it. So it's less work for you up front because the work really comes after death in probate. A revocable trust is the exact opposite. It's more costly up front because it is less costly after your death. It's more work up front, and then it is less work after your death. And so that is something that makes a difference to people. And another piece of it is a revocable trust is not appropriate for everyone because a lot of it hinges on the types of assets. So for example, someone whose only asset is their IRA and otherwise they rent, they don't own, and maybe they have a car and a small bank account, but really their main asset is their IRA. Well, an IRA is something that has a beneficiary designation. We don't retitle the IRA into the trust because it would trigger all of the income tax at once. So we don't do that. So someone like I just described, who really their main asset is their IRA, they really wouldn't benefit from a revocable trust because they don't have the assets that would make the revocable trust a worthwhile endeavor. So it is something that it's not one appropriate estate plan for every person. It just requires talking through particular assets, particular circumstances. I mean, I've had people who have said, I'm not married, I don't have children, my brother's going to be handling my estate at my death. I love him, but he can deal with probate. I'm not worried about it. And they therefore choose to pay less up front and just do the simple last will and testament as their document. So everyone has different reasons for making the decisions, and it's just part of what we have to talk through.
Makes good sense. Thank you. Next question is, what does inheritance tax apply to? I'm leaving my assets to my niece.
So inheritance tax at this point is 10%, and it applies to almost everything. It doesn't apply to life insurance proceeds if they're handled appropriately. And there are a few other things in the statute that are excluded, but really the best way to think about it is that it applies to all assets that your niece will receive from you, and that just basically means she'll receive 10% less. So, you know, it doesn't mean that your niece will have to come up with 10% to pay the tax. It simply means that what she inherits will be reduced by the 10% tax. But it applies to pretty much everything except life insurance proceeds.
Okay. And then we have a repeat question. So I wanted to acknowledge it though. Can you provide more details on using professionals for financial and medical powers of attorney? This is a particular issue for older single people with shrinking pools of family and friends. So I think we have covered that. Would you agree with that statement, Olivia?
Yes.
Okay, yeah. Okay, so let me get to the next one here. Okay, so our joint revocable trust allows keeping assets under separate names. I'm confused as to when all separate assets must be renamed to the trust.
So with married couples, the options are to do a joint revocable trust or individual revocable trusts or a combination. There are times where that's appropriate. And so usually the guiding principles to choose one versus the other, it's not a perfect system, but the conversation that I usually have is, number one, how do you own most assets? Do you own most assets jointly, or do you own most assets individually? And if individually, is there a reason for that? Is that intentional, and is that your preference? And so that's a big part of deciding whether to utilize a joint trust versus individual trusts. Because the reality is, if it's important to you to keep assets separate and to have separate ownership and separate individual ownership and control and treatment of those assets, that will be cleaner and more possible to accomplish if we do individual trusts. Whereas people who say, oh no, I have this individual account, but it's just because I never added her name to it. It's fine. I don't have any problem adding her name to it. Well, then we can do a joint trust because it's not important to you to keep it individual. So that's just part of the conversation that I have. It also can be dictated by if taxes are a concern. So if we're dealing with an estate where there are estate tax implications, or maybe, it's frequently better to do individual trusts simply because it makes it cleaner and more clear how much is in one estate when one spouse dies, in order for us to be able to really treat that in the best way possible from an estate tax perspective. So joint versus individual for a married couple, it's part of the conversation about how are assets titled now, what are the reasons for that, what are your preferences and concerns, and then generally speaking, do we need to also take estate tax into consideration?
Okay, great. And it looks like 2 more questions. Thanks to everybody for their questions. Really good. They help everybody learn. So the next question is, are there tasks that the administrator can do instead of the attorney in order to save the trust money?
Absolutely. And the best attorney for this sort of thing is the attorney who gives you that option. And that's something that we really try to do, which is to say, these are the things that need to be done. Do you want to handle them? Or do you want me to handle them? Or do you want to share handling them? And so, yes, there are certainly tasks that are part of the administration that can be left to the trustee to handle instead of the attorneys. And, you know, as with everything, it's always a matter of, so for me personally, there are some times where I choose to pay someone to do something, not because I can't do it, but because I don't have time. And so that's part of it too, is if the trustee has time and wants to, then they can just follow the guidance of the attorney. But if they really would rather just have the attorney handle it, that's something that they can choose to do as well.
Okay, and it looks like we might have another 1 or 2 here. Sorry for the repeat. Do you have any information details regarding specifically medical power of attorney? I'm struggling to find any resources in this area. So I believe that's something we covered here in the presentation a bit. Anything you care to add to that, Olivia?
Well, certainly a lot of good information can be found on the Maryland Attorney General website.
Yeah.
So healthcare power of attorney in Maryland is referred to as an advanced medical directive. So that may help turn up more information. But the Maryland...
Sorry, go ahead.
Oh, just the Maryland Attorney General certainly has a lot of educational literature and that sort of thing, but also working with us, I provide lots of guidance on that and working through it page by page with clients to make sure that every provision is understood and thought through and appropriately tailored to a particular client's needs and concerns.
Yeah, absolutely. And I'll go ahead and provide a link to that, but you know, to Olivia's point, and she'll reiterate this, you know, when you engage with us for your planning or to update documents or just to begin the planning process, we provide, you know, ongoing education through your planning process. So, you know, each meeting is kind of like, you know, continuing education, and you'll walk away knowing a lot more than you did when you walked in. So it looks like the last question will be, how can a home be transferred under a will to avoid probate, to minimize taxes, etc.?
Well, so as an estate planning attorney, my answer to that question is that my recommendation almost always is that the best mechanism to transfer real estate without going through probate is through using a trust. There is a type of deed called a life estate deed that will transfer real estate at your death to whomever you want to receive it without the need to go through probate. But that type of deed should not be used without counseling and guidance from an attorney to make sure that the risks and complications that you need to be aware of are part of your decision making. So as I said, with regard to people's inclination to think that the simplest thing to do is to skip all of this by just making all of their accounts payable on death, life estate deed on their house, there you go, don't need to do anything else. That may be fine, but 9 times out of 10, it's not. And the only way that you can make an educated decision about whether that's the appropriate thing for you and your particular circumstances is to actually have a conversation with a professional who can guide you through thinking about all of the risks and possible negative consequences that can happen from doing things that way. So my answer is that for most people, the best way to avoid probate on the transfer of a house is to implement and utilize trust planning.
Okay. It looks like, well, one last one, and it looks like a pretty straightforward answer. Can anyone be an IRA beneficiary, such as a niece or a friend?
Certainly. There are different tax consequences and different considerations for different types of beneficiaries, but yes, anyone can be a beneficiary.
Okay, great. Well, thanks again to everybody for their questions. Thanks for being here today. Couple last thoughts. I want to thank Olivia, always very thorough and again, easy to understand. I would just say to everybody, you've been here, you've educated yourselves today. Encourage you to take action if you have a need. Everyone, as Olivia said, needs planning. It's imperative if you're over 18. So if you're just getting started, if you're one of those people that said, I need help, or you have old documents that haven't been revisited in 15 years, consider setting a time to meet with Olivia. As you can see, she knows what she's talking about. She's also a really nice person. I've known her for a long time. There's no cost for the initial consultation, which will be a time where you work with her and she gets to know you to set a roadmap for where you may want to go with your planning. So we can do that. You can just email me or email Olivia, note it on the post-webinar feedback, and we'll kind of get the ball rolling. Briefly, since we're up against the clock here, webinar series, what we have coming up for you, April 7th, next Wednesday, the impacts of hearing loss as we age. We're really excited about that. Chesapeake Hearing Center's Dr. Tyler Ropp, who's a clinical audiologist. He's going to be doing a presentation about that. Really great guy and great people over there at Chesapeake Hearing Centers, and we're looking forward to that new topic. A couple recurring topics that we have coming up on the 14th and 28th of April. Understanding estate and trust administration, always very popular and something a lot of people need to know about. And on the 28th, also a recurring topic, very popular, what families need to know about planning for a loved one with special needs. So that's always been one of our very popular presentations. And Mr. Stephen Elville, our managing principal, will be talking about both of those topics on the 14th and 28th. So I'll send the links out in my post-webinar email. and I'll send out the information about the Attorney General's website as well as the video for today's presentation. So I think that about rounds everything up for today. Thanks for being here. Have a great rest of your week and a nice upcoming Easter weekend, everybody. Take care, and thanks for being part of the Elville webinar series.